Well, Judge Sulet Porterill was scathing. She ruled that Nandipha Magudumana's claim that the matter was urgent was self-created, and was also critical of her legal team, who the judge said placed the opponents under undue pressure by the filing of their late papers, and that they knew the documentary would be aired as early as August.
The application for the doctor was set down the day before the streaming of the documentary. This is simply inaction until the hour of reckoning. It is common cause that already on 20 August 2025, the doctor and Ms. Reid knew that the documentary would be screened on 12 September 2025. The trailer was in fact aired on 20 August 2025. This is 19 days, close to 2 weeks in court days before the launching of this application. Even if a court should take into consideration that consultation is difficult with an incarcerated person, she had, according to her affidavit, had telephonic consultations and in-person consultations with the doctor. And Ms. Reid should have obtained the necessary permission to have an in-person consultation with the doctor any day after 20 August 2025. I find that the application is not urgent and it is struck from the roll. A day bonus proprius cost order was sought against Ms. Reid. I have exercised my discretion, and the order of costs is as follows. The applicant is to pay the costs on scale C.
On Thabo Bester's application, Judge Porterill found that if he finds that he should suffer defamation, he has a redress.
More importantly, he does not at all in his application set out why he will not obtain substantial redress. There is not even a single averment in this application setting this out. The quoted case law is clear that this is an absolute requirement, because if substantive redress can be obtained, the urgent application must fail. But in any event, Mr. Bester can obtain substantial redress. Defamation can be sued for. The case law is clear. Furthermore, the right to silence, the right to a fair trial, and the right to be innocent until found guilty is not in any way affected by the utterances referred to. No judge will be influenced by any documentary. Witnesses will be exposed to cross-examination. The public will form an opinion, but that is a byproduct of the criminal justice system and does not affect the rights of Mr. Bester as claimed.
Our conversations with the respondents was never about go to court. Yes, we are the ones that said, let's try and negotiate before we go to court, because we didn't want to waste the court's time. And in their conversation, it was never that fact that it basically what they were saying was that you don't have a case. You have been ill-advised. And when you get that information, you have to go and consult. And you are threatened with costs. So it was basically a difficult one to maneuver, because on one part, you are told that you can't go to court, and then on the other, you have to take instruction. And the client, when a client wants their voice and their case to be heard, what else can you do?
We are disappointed that the matter was dismissed. As you heard the judge, our matter was dismissed on the basis that the court finds that our client has substantial redress that's available to him that he can bring at a later stage, and that prior restraint in this event is not the only adequate redress available to him. Yeah. So we are extremely disappointed, because obviously we view that quite differently. We do not believe that bringing damages at a later stage will substantially restore the harm that is being done to our client.
Griselda Lewis, SABC News at the High Court in Pretoria.